What is the Virginia Car Accident Statute of Limitations? Virginia's Car Accident Statute of Limitations sets a strict deadline for filing a lawsuit, and understanding that deadline can mean the difference between securing compensation and losing your rights entirely. Under Virginia Code Section 8.01 to 243, you generally have 2 years from the date of a car accident to file a personal injury lawsuit in court. This 2-year clock begins on the day of the crash, not when you discover your injuries, so waiting to feel the full impact of your injuries does not extend the deadline. If you were rear-ended on Route 17 on January 15, 2024, you must file by January 15, 2026 or risk dismissal of your claim. The law provides a different timeline for property damage, giving you 5 years from the accident to sue for vehicle damage or other property losses. Wrongful death cases arising from a crash are also subject to the statute, but the 2-year period starts on the date of death rather than the accident. Because these deadlines are enforced strictly, missing them by even a single day can bar you from recovering damages for medical bills, lost wages, and pain and suffering. Virginia law recognizes several narrow exceptions that can pause or extend the statute of limitations. If the injured person is a minor under 18, the clock usually does not start until the child turns 18, giving them until age 20 to file. When a person is legally incapacitated and cannot manage their own affairs, the deadline may be tolled until a guardian or conservator is appointed, but ordinary injuries or disabilities do not automatically extend the period. If the defendant leaves Virginia after the crash and before a lawsuit can be filed, the time they spend outside the state may not count against the deadline. Claims against government entities require special notice within 6 months for local government claims and within 1 year for claims against the Commonwealth, and these notice requirements are shorter than the 2-year lawsuit deadline. Failing to provide timely notice or include required information can bar your entire claim even if you later file suit on time. The statute of limitations applies to court filings and not to insurance claims, which typically require prompt notice or reporting within days or weeks under your policy. Insurance companies may deny claims that are reported too late even if the 2-year window remains open, so reading your policy and consulting a lawyer quickly helps protect your rights. Virginia follows a strict contributory negligence rule, meaning that if you contributed to the accident even by 1%, you may be barred from recovering compensation. This rule does not change the statute of limitations, but it encourages you to act early so your attorney can gather evidence and counterclaims that you shared fault. As the 2-year deadline approaches, insurance adjusters gain leverage because they know you have little time to prepare a lawsuit and may pressure you into accepting a low settlement. Filing a lawsuit before the deadline preserves your legal rights and often leads to more reasonable settlement offers because it signals seriousness and prevents insurers from running out of the clock. Most car accident cases settle before trial, but filing suit on time allows negotiations to continue without the looming risk of your claim expiring. Building a strong case takes time, because your attorney must obtain police reports and accident scene photographs, interview witnesses, request medical records, consult accident reconstruction experts, and review insurance coverage. Medical treatment may still be ongoing, and filing too early can lead to undervaluing your injuries, so an experienced attorney can help balance the need to protect the deadline with the need to document the full extent of your damages. Insurance adjusters monitor statute of limitations deadlines closely, and hiring a lawyer early signals that you are serious about your claim and gives your attorney time to prepare for trial if necessary. In summary, Virginia law gives you 2 years to file a personal injury lawsuit after a car accident, 5 years for property damage, and imposes shorter notice requirements for government claims, with limited exceptions for minors, incapacity, and defendants who leave the state. Understanding and complying with these deadlines protects your right to compensation and strengthens your negotiating position. If you have questions about how the statute of limitations applies to your situation or need help preparing your case, reach out to Gibson-Singleton Virginia injury attorneys for guidance. Ken Gibson and John Singleton are seasoned trial lawyers and former U.S. Marines who handle car accident cases in Gloucester County and throughout the Middle Peninsula. They have personal insight into the toll an accident takes on victims, And they know how insurers operate because one of them worked for an insurance defense firm before representing injury victims. Working with a knowledgeable attorney early allows you to investigate your case thoroughly, counter contributory negligence arguments, and file suit before the deadline pressures you into an unfair settlement. Deadlines add stress to an already difficult situation, so focusing on healing while your legal team manages the clock can make a significant difference in your recovery. For a free consultation, call Gibson Singleton Virginia Injury Attorneys at 804-413-6777 or visit us at 4073 George Washington Memorial Highway, Hayes, Virginia, 23072, United States. Our law firm proudly serves families throughout Gloucester County and stands ready to help you protect your rights under Virginia law.